Let's discuss the formation of LLCs, limited liability companies. Once you understand the incorporation process, the formation of a corporation, it's easy to understand the LLC process. It's very similar. So in this case, you submit articles of organization to the Secretary of State, not articles of incorporation, but articles of organization, of course, with a fee. And the items in those articles of organization are very similar to the items we saw in the articles of incorporation, with a few exceptions, and we'll go through those. All right, let's take a more detailed look at the articles of organization that you will file with the Secretary of State to form your LLC. They're very similar to articles of incorporation, but there are some differences. So, number one, there will be no authorized stock. LLCs don't have stock, they have membership interests. So if you are an investor in an LLC, you will receive a membership interest in the LLC. You will not receive membership interests. You will receive a membership interest in the LLC. The rights, the relative rights of each of these membership interests, right? The rights of your membership interest will usually not be described in the articles of incorporation, but in another document that is very important to the LLC, the operating agreement. Now, the operating agreement we'll discuss a little bit more in detail subsequently, but for now, remember that the operating agreement is a very important document for the formation of an LLC. Now, the operating agreement does not get filed by the Secretary of State. You don't submit it to the Secretary of State. You submit the articles of an organization to the Secretary of State, and once the articles of an organization have been filed by the Secretary of State, then you have an LLC. Remember, LLCs, as a default, generally do not have centralized management. No board of directors for the LLCs, but you can have a board of directors, or you can have a manager or managers. If you want to have a manager-managed LLC, in contrast to the default member-managed LLC. If you want to have a manager-managed LLC, you usually have to indicate that in the articles of organization. Not always, but in most jurisdictions, you have to put that in your articles of organization. Just a quick look at the form articles of organization you would use to organize a limited liability company in Kentucky. You see, it's very similar to the articles of incorporation. The name of the company, the address of the initial registered office, the initial registered agent, and the mailing address of the limited liability company. All right, similar to a corporation, once you have formed your LLC, there are certain regular filings that you have to make with the Secretary of State, namely the annual report and certain other filings. Just like we discussed with the corporation, the annual report that you need to file with the Secretary of State is quite simple. There are other required filings that you have to make to the Secretary of State when you are making some changes. So for example, you can change the registered agent of your LLC. You're going to amend the articles of organization of the LLC. If you're going to dissolve, etc., you have to make certain submissions, certain filings with the Secretary of State, just like we discussed when we discussed the corporation. All right, let's talk about what it means to be a foreign LLC. Remember, we talked about the idea of being a foreign corporation. If you're incorporated in one state, as far as another state is concerned, you are a foreign corporation. So if you're incorporated in New York, California considers you to be a foreign corporation. If you want to transact business in California, you have to file as a foreign corporation. So you'd have to do the same for an LLC. So here's the Kentucky Secretary of State form for that. Look, it applies to any business entity, right? So it's a certificate of authority for a foreign business entity, any business entity. So it could apply for a corporation. It also, this form equally applies if you want to be a foreign LLC transacting business in Kentucky. And you see, it applies to limited liability companies as well. All right, let's talk about what you should do if your LLC is doing business under an assumed name. The Secretary of State website has a form, and that form applies not just to corporations, but any foreign or domestic business entity. So if you have an LLC that's called Alpha Beta Foods LLC, and you want to do business as Paulie's Pizza Truck, you have to file this form with the Kentucky Secretary of State, right? And you see it applies to domestic limited liability companies and foreign limited liability companies. Let's talk about the LLC Operating Agreement. Now, remember, when you're forming an LLC, you will submit articles of organization to the Secretary of State. Those articles of organization are very similar to the articles of incorporation you would submit if you were forming a corporation. But for the LLC, the articles of organization are not quite as important as the articles of incorporation are for the corporation. If you are forming a corporation, there are certain things that you would put in the articles of incorporation to protect your client that you wouldn't necessarily put in the articles of organization. You would put, for an LLC, you would put those things in the operating agreement. So you can look at the LLC operating agreement as kind of a mix between a shareholders agreement that you would see in the corporate context and the bylaws that you would see in the corporate context. So the operating agreement is kind of this weird mix of bylaws and shareholders agreement. All right, so the operating agreement is usually between the members and the company. If you have several members, then all members would sign it, and the limited liability company would also sign the operating agreement. It is very analogous, very similar to the shareholders agreement that we see in closely held businesses. Remember, we talked about the shareholder agreement when we talked about the formation of the corporation, and a shareholders agreement will generally address issues of internal governance, the business of the corporation, and it would have a buy-sell agreement. Remember the buy-sell agreement, very important provision in shareholders agreement, which says, listen, if one of the shareholders wants to sell her shares, can she sell it to a third party? Does she have to give the other shareholders a right of first option or a right of first refusal? Or if she wants to buy the shares of one of the other shareholders, does she have a right to? Does she have to do that? Those are all things we would put in a buy-sell agreement for a corporation. We would put very similar provisions in a in an operating agreement for an LLC. Is an operating agreement required under the law? Well, it really depends on your jurisdiction. As a practical matter, most lawyers will create an operating agreement when they set up an LLC for a client. Some jurisdictions require the LLC to have an operating agreement, just as most jurisdictions require a corporation to have bylaws. Some jurisdictions do not require the LLC to have an operating agreement. Now, what about a one-member LLC? What if you have an LLC and there's only one member? are you going to have an operating agreement? Sounds strange, right? There's only one member, so why do we need any kind of agreement? Well, think of it as an agreement between the member and the LLC. And in that sense, it's more like bylaws than a shareholder agreement. All right, let's talk about promoter liability in the LLC context. Remember, we talked about this in the context of the formation of the corporation. Remember what a promoter is. A promoter is a person behind the business and the creation of the entity. The question was, will the promoter be liable for the debts of the business? And we talk about two scenarios where the promoter enters into contracts on behalf of the LLC, in this case, when the LLC has not yet been formed. The promoter might have a really great opportunity to enter into some sort of transaction for the LLC, but the LLC has not yet been formed. Will the promoter be personally liable for that contract? And then we have the idea of defective organization. Remember, we talked about defective incorporation. In this case, because we don't have a corporation, we have an LLC, we'll talk about defective organization. And will the promoter be liable? Will the agent be liable for the contracts she enters into on behalf of an LLC that really wasn't formed because there was some sort of defective organization? We talked about two doctrines that courts might apply in these situations. We talked about de facto incorporation under the LLC. We talked about, we would refer to de facto organization rather than de facto incorporation. And we also talked about corporation by estoppel. In the LLC context, we talk about LLC by estoppel. So go back and refresh your memories about what we discussed when we discussed these issues with the corporation, and they would apply equally in most jurisdictions to the LLC context. Let's talk about the legal consequences of forming an LLC and how they are somewhat different from the legal consequences of forming a corporation. First, limited liability is the same. Just as the shareholders are protected with limited liability in the corporation, the members of an LLC are protected with limited liability. In other words, the members of the LLC will not be personally liable for the debts of the LLC. They will only be exposed up to the amount that they have invested in the LLC as their capital contribution to the LLC. So that's the same. There are a couple other things that are a little bit different. So number one, if you are a member in an LLC, you have an equal share in the profits. You have a right to share equally in the profits. This is a per capita rule. It's not based on investment proportion. So for example, if we have 4 members of our LLC and I'm one of those members, I'm entitled to 1/4, to a quarter of the profits, even if I have not invested as much in the LLC as the other members. Now, the other members might not be happy about that, but that's the default rule. If they want to change that rule, then we have to change that rule through the operating agreement. We also have equal voting rights. Once again, if I'm in an LLC and there are 3 other members, there are 4 members altogether, I have 25% of the voting rights. I have 1/4 of the voting rights. It's a per capita rule. Again, if we want to change that, then we can change that through the operating agreement. And finally, I have equal rights to management. Even if my investment proportion is much less than the other members, I have an equal right to management. If the other members are not happy about that, then we have to change that in the operating agreement. Now, for equal share in profits, this is the case, I think, in most jurisdictions. This is the default rule, but it might vary depending on jurisdictions. In some jurisdictions, you might share profits in proportion to your investment contribution to the LLC. Equal voting rights, the same thing. equal voting rights, a per capita voting rights is probably the default in most jurisdictions. Some jurisdictions you might have voting rights in proportion to your investment contribution to the LLC. And equal rights to management. Remember, you can select a manager-managed LLC. If you select a manager-managed LLC, then the managers manage the business and the members do not manage the business. So in a manager-managed LLC, the members have no right to management in the LLC. Let's compare the formation of an LLC to the formation of a corporation. With an LLC, you file articles of organization with the Secretary of State. With a corporation, you file articles of incorporation with the Secretary of State. With the LLC, you have an operating agreement which prevails over the articles. If there's a conflict between what's in the operating agreement and what's in the articles, the operating agreement prevails. With a corporation, you have bylaws, and normally you will have a shareholders agreement, but the articles of incorporation control. So if there is some sort of conflict between what is in the articles of incorporation and the bylaws, the articles prevail. If there is a conflict between what is in the shareholders agreement and what is in the articles of incorporation, the articles of incorporation prevail. With an LLC, your equity investors are called members and they enjoy limited liability. With a corporation, your equity owners, your equity holders are called shareholders or stockholders, and they also enjoy limited liability. In LLCs, your ownership interest is called a membership interest. In a corporation, ownership interests, equity interests are called shares or stock. In an LLC, you do not usually have authorized stock or shares. In a corporation, you have authorized shares or authorized stock or authorized capital. In an LLC, the default rule in most jurisdictions is that members directly manage the business and affairs of the LLC. In a corporation, the default rule is that we have centralized management. The board of directors manage the business and affairs of the corporation. In an LLC, members have equal rights to management without regard to their relative investments in the LLC, without regard to the proportion of their contribution to the LLC. In the corporation, shareholders have no rights to management. If you are a shareholder in a corporation and you want to manage the day-to-day business of the company, you want to manage the business and affairs of the company, you must find a way to get yourself onto the board of directors. In an LLC, members have equal voting rights, 1 vote per member, without regard to relative proportion of investment or capital contribution to the LLC. In the corporation, shareholders' voting rights are based on their shareholdings. It's 1 vote per share. In the LLC, the members have equal rights to share in the profits without regard to their relative capital contributions. And in the corporation, your right to profits is based on your shareholdings, right? So each share has an equal right to receive profit. If you hold more shares, then you have more rights to receive profits, or you have rights to receive more profits. That's a better way to state that.